Stories subsequently reported that no presidential finding and no congressional oversight existed on MEK operations. In March 2007, Hirsch reported in the New Yorker magazine that the Bush administration was attempting to stem the growth of Shiite influence in the Middle East, specifically the Iranian government and Hezbollah in Lebanon, by funding violent Sunni organizations without any congressional authorization or oversight. Hirsch said funds had been given to, quote, 3 Sunni jihadist groups connected to al-Qaeda, unquote, that, quote, wanted to take on Hezbollah. In April 2008, the Los Angeles Times reported that conflicts with insurgent groups along Iran's borders were understood by the Iranian government as a proxy war with the United States. Among the groups the U.S. DOD is supporting, according to this report, is the Party for Free Life in Kurdistan, known by its Kurdish acronym, PJAK. The United States has provided foodstuffs, economic assistance, medical supplies, and Russian military equipment, some of it funneled through non-profit groups. In May 2008, Andrew Coburn reported on Counterpunch that President Bush, 6 weeks earlier, had signed a secret finding authorizing a covert offensive against the Iranian regime. President Bush's secret directive covers actions across an area stretching from Lebanon to Afghanistan and purports to sanction actions up to and including the funding of organizations like the MEK and the assassination of public officials. All of these actions by the President and his agents and subordinates exhibit a disregard for the truth and a recklessness with regard to national security, nuclear proliferation, and the global role of the United States military that is not merely unacceptable, but is dangerous in a commander-in-chief. In all these actions and decisions, President George W. Bush has acted in a manner contrary to his trust as President and Commander-in-Chief, and subversive of constitutional government, to the prejudice and the cause of law and justice, and to the manifest injury of the people of the United States. Wherefore, President George Bush, by such conduct, is guilty of an impeachable offense warranting removal from office. Article 22, creating secret laws. In his conduct while President of the United States, George W. Bush, in violation of his constitutional oath to faithfully execute the office of President of the United States, and to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty under Article 2, Section 3 of the Constitution, to take care that the laws be faithfully executed, has both personally and acting through his agents and subordinates, together with the Vice President, established a body of secret laws through the issuance of legal opinions by the Department of Justice's Office of Legal Counsel. The Office of Legal Counsel's March 14, 2003 interrogation memorandum, known as the UYOO Memorandum, as law for the executive branch. On April 29, 2008, House Judiciary Committee Chairman John Conyers and the Subcommittee on the Constitution, Civil Rights, and Civil Liberties Chairman Gerald Nadler wrote in a letter to Attorney General Michael Mukasey, quote, "It appears to us that there was never any legitimate basis for the purely legal analysis contained in this document to be classified in the first place. The U Memorandum does not describe sources and methods of intelligence gathering or any specific facts regarding any interrogation activities. Instead, it consists almost entirely of the Department's legal views, which are not properly kept secret from Congress and the American people. J. William Leonard, the director of the National Archives Office of Information Security Oversight and a top expert in this field, concurs, commenting that, quote, the document in question is purely a legal analysis that contains nothing that would justify classification. In addition, the U memorandum suggests an extraordinary breadth and aggressiveness of the Office of Legal Counsel's secret legal opinion making. Much attention has rightly been given to the statement in footnote 10 in the March 14, 2003 memorandum that in an October 23, 2001 opinion, the Office of Legal Counsel concluded that the Fourth Amendment had no application to domestic military operations. As you know, we requested a copy of that memorandum on no less than 4 prior occasions, and we continue to demand access to this important document. In addition to this opinion, however, the U memorandum references at least 10 other Office of Legal Counsel opinions on weighty matters of great interest to the American people that also do not appear to have been released. These appear to cover matters such as the power of Congress to regulate the conduct of military commissions, legal constraints on the military detention of United States citizens, legal rules applicable to the boarding and searching of foreign ships, the President's authority to render U.S. detainees to the custody of foreign governments, and the President's authority to breach or suspend U.S. treaty obligations. Furthermore, it's been more than 5 years since the U memorandum was authorized, raising the question of how many other such memoranda and letters have been secretly authored and utilized by the administration. Indeed, a recent court filing by the Department in Freedom of Information litigation involving the Central Intelligence Agency identifies 8 additional secret Office of Legal Counsel opinions dating from August 6, 2004 to February 18, 2007. Given that these reflect only Office of Legal Counsel memoranda identified in the files of the CIA, and based on the sampling procedures under which that listing was generated, it appears that these represent only a small portion of the secret Office of Legal Counsel memoranda generated during this time, with the true number almost certainly being much higher. Senator Russ Feingold, in a statement during an April 30, 2008 Senate hearing, stated, and I quote, "It is a basic tenet of democracy that the people have a right to know the law. In keeping with this principle, the laws passed by Congress and the case law of our courts have historically been a matter of public record. And when it became apparent in the middle of the 20th century that federal agencies were increasingly creating a body of non-public administrative law, Congress passed several statutes requiring this law to be made public for the express purpose of preventing a regime of secret law. That purpose today is being thwarted. Congressional enactments and agency regulations are, for the most part, still public. But the law that applies in this country is determined not only by statutes and regulations, but also by the controlling interpretations of courts, and in some cases, the executive branch. More and more, this body of executive and judicial law is being kept secret from the public, and too often from Congress as well." Continuing to quote, "A legal interpretation by the Justice Department's Office of Legal Counsel binds the entire executive branch, just like a regulation or the ruling of a court. In the words of former OLC head Jack Goldsmith, these executive branch precedents are law for the executive branch. The U memorandum was, for a 9-month period in 2003, until it was withdrawn by Mr. Goldsmith, the law that this administration followed when it came to matters of torture. And of course, that law was essentially a declaration that few, if any, laws applied.